confused myself. Does that mean that the clock has been altered in the meantime? It has. How very efficient the services here are. Right, off we go. Yeah.
My Lords, before the short adjournment, I said I would come back to you on whether there's a statutory provision assisting you with the apportionment. It's section 19 of the VAT Act, subsection 4, and we're going to get copies to you tomorrow morning to hand up. But it says the following: where a supply of any goods or services is not the only matter to which a consideration in money relates, the supply shall be deemed to be for such part of the consideration as is properly attributable to it. So if one were to have the payment of an amount for transactions that take place partly inside a VAT group and therefore do not exist, must be disregarded, and partly for transactions that occur outside of that group, one have a payment, a consideration in money being paid for something that is not just a supply of goods or services, then you treat the consideration that is for the part that is a supply, the bit outside the group, as that part which is properly attributable to it. And what that means and how you determine that on the facts is an exercise.
What was the reference?
It's section 19, subsection 4 of the 1994 VAT Act.
Okay, well, yes, if you can bring it tomorrow, but I'm sure we will go into tomorrow now, but if it were possible to send it electronically to our clerks, we can look at it overnight.
We'll do that.
Thank you.
Another thing to point out is that on the facts of Svenska, the supplies of management services were in fact made both in the pre-group period and continuing into the period during which Svenska and the London branch were members of the same VAT group. So that was in fact on its facts a supply that continued from a pre-VAT group period into a post-VAT group period. The parties agreed, I will take you to this bit, it's tab 8 for your records, page 94. The issue in the present case relates to the period.
Sorry, I wasn't keeping up. Page?
Page 94 in tab 8 of Svenska. The last sentence of that first part paragraph, the issue in the present case relates to the period from 1st of June 1987 to 31st of July 1991. So the
Sorry, what?
Restricted
Between A and B.
Between A and B. So they restricted the issue before the court in that case to the period before Svenska and London branch became VAT grouped, and it's for that period that on page 101, just under F in the margin, it is common ground between the parties that Regulation 23, now Regulation 90, applied to those services. But on its fact, the supply is continued.
And the invoice that was issued related to that period, presumably.
Yes.
So where were you illustrating from, on page 779 or page 191?
Page 101, below F, common ground between the parties.
Below F. Precisely.
So we were in BJ Rice, which
Yes.
is behind tab 6 of the authorities bundle. And we were on page 67. We just finished looking at the judgment there and moving on to Lord Justice Ward.
So just before you do, what do you say is the basis of Lord Justice Dawson's
basis of his judgment is at the bottom of page 66, between G and H, in fact at H. It says, in all other respects, the existence of a chargeable transaction has to be determined at a time when the supply is actually made. So it is at that point you need to look to see whether the 4 criteria for imposing a charge to VAT have been satisfied.
Yeah.
And then in Lord Justice...
Hang on 1 second. Yes, I see why you made that the key part, but in fact, the passage he approves from Broadwell says effectively the same thing in different language.
My lord, yes. Lord Justice Ward's judgment begins on page 67. If you turn over to page 68, you can see towards the bottom there he is setting out provisions, this is of the 1983 VAT Act, section 1 and section 2, continues over the page. And then at the top of page 69, the plain and accepted meaning of subsection 1 is that tax is not charged on any supply of service which is made by a person who is not a taxable person. The writer is not a taxable person at the time he performed his contract, and on the ordinary meaning of the words, the performance of the contract constituted a supply of services. I do not understand Mrs. Hall, for the Commissioners, to dissent from the proposition. Her submission is that supply does not bear its ordinary meaning, and a series of fictions ascribe different meanings to the word. Subsection 3, this is now section 1 sub 2 of the 94 VAT Act, seems to me again to acknowledge the distinction between the liability for the tax, which being a tax on a supply falls on the maker of the supply, and the payment of the tax which becomes due at the time of supply. Since liability has already been established, the words becomes due are unnecessary for the purpose of creating the liability. Due is here used in the sense of payable. The 2 parts of the subsection accordingly provide that, firstly, the tax on any supply is the liability of the supplier, and secondly, the tax is payable at the time of the supply. The time for payment, and not the imposition of liability in the first part, is subject to and so can be overridden by other provisions about accounting and supply. So he's making the same point, which is the time of supply rules cannot impose a tax charge where one would not exist at the time of the actual supply, the transaction constituting the supply. Just a short point to note, at the bottom of page 70, H in the margin, it was common ground both here and in the Court of Tribunal below that Regulation 23 applied. So it was common ground in BJ Rice at the time of supply provision, what is now Regulation 90 applied. And of course, we're proceeding in this part of my submissions on the basis that I've been unsuccessful in the first part of my submissions and Regulation 90 does apply. And then, if I might invite your lordships to read over the page on page 71. Perhaps just start at the bottom of page 70 so you can see Miss Hall's argument, and then continue our part company with this approach. He's talking about Miss Hall's argument to the very top of page 72.
Sorry, I'm not sure I did quite follow.
I'm so sorry. It's essentially the entirety of page 71.
Yeah.
But it takes in a little bit from the bottom of page 70 and a little bit from the top of page 72.
At E,
Yes, my lord.
am I confusing myself? But by reference to his previous language, does he mean where there's liability determined when, but not whether the tax is to be payable rather than is to be charged? Is that the distinction he's making?
Yes, I would say that by charged he means payable. Because he presupposes there is a liability.
Right.
Well, I'm not sure. I don't think it matters, but it's not quite how I read it.
You're right.
I read it as what he's saying is that sections 4 and 5 only deal with the case where there already is a liability, and then they determine when it's to be charged. But they don't deal with the case of whether there is a liability at all.
Yeah, I think I was really just jibbing at his word charged, because earlier he's made the distinction between chargeable and payable, hasn't he? Maybe I
Yes,
missed it.
yes. The charge to tax throws us back to section 1. So as I read it, he's saying the same as Mr. Oliver. The role is to identify the time of supply given that there has been one which is in charge, but it's not to determine whether there is a charge. I think that's
Charge or chargeable perhaps in the sense meant, I know he doesn't make reference to this article, but Article 62 of the Principal VAT Directive, which talks about chargeable when the tax authority becomes entitled to claim the tax, even if the time of payment may be deferred. So charged as in tax authority is entitled to claim it, but obviously the time of payment may in fact be later.
Yes, I think speaking for myself, I read to the end of the passage you wanted us to read. Oh, sorry, did you want us to read right to the end of the judgment?
No, my lord, just to the top of the very top of page 72 is sufficient. So it's the same point, which is the
Yes.
time of provision, at the time of supply rules, cannot impose a liability, a tax liability, where one doesn't exist at the time of the supply. And then I don't need to take you through Sir Ralph Gibson's judgment, but merely to note it is dissenting, so that when you come to it, if my learned friend takes you to it, it is a dissenting judgment. Even as it's with the judgment in B.J. Rice narrowly, Regulation 19, or timing regulation, cannot be applied to render an occurrence that wasn't a taxable event when it happened into a taxable event, particularly when at the time the transaction was completed, the supplier was not a taxable person. And in our case, Silverfleet, the supplier, was not a taxable person when it in fact performed the investment management services. And authority for that you can find in the case of Amplia Scientifica, which is a CJEU case. It's in the authorities bundle behind tab 18.
sorry. What did you say this was authority for?
Authority for the fact that Silverfleet was not a taxable person at the time it actually performed the investment management services. That is during the group period.
Thank you.
So behind tab 18, Amplia Scientifica, we go straight into the judgment of the court. Page 286, my lords, you can see at the bottom there, the court sets out the definition of a taxable person, which we have seen already, the general definition for the purpose of tax. On page 287, They set out Article 4, Sub 4 of the 6th Directive, which is now Article 11. This is the provision that empowers member states to treat as a single taxable person, closely connected persons. Then, if you could please turn to page 289. Paragraph 12, and 14 and 15 set out the facts and the issue in this case. Perhaps if you might just read those paragraphs to yourselves.
Yeah.
And then page 292, paragraph 17. The first question is based on the premise that the 1979 decree under which reminders for VAT non-payment to issue in the main proceedings were issued constitutes an implementation of the authority conferred on all member states by the second paragraph of Article 4 Sub 4 to treat as a single taxable person for VAT purposes. Different persons who are established in the territory of the country but are legally independent, where those persons are closely bound, etc. Paragraph 18, it should be noted, first of all, as the very wording of that provision makes clear, that it can be implemented only after the Advisory Committee on VAT has been consulted. However, it's not disputed in the case of the 79 decree, the Italian Republic did not consult the committee. Paragraph 19, it is to be observed, secondly, that the effect of implementing the scheme established in the second subparagraph of Article 4 Sub 4 of the 6th Directive is that the national legislation adopted on the basis of that provision allows persons, in particular companies, which are bound to one another by financial, economic, and organisational links, no longer to be treated as separate taxable persons for the purposes of VAT, but to be treated as a single taxable person. Thus, where that provision is implemented by a member state, the closely linked person or persons within the meaning of that provision cannot be treated as a taxable person or persons within the meaning of Article 4 Sub 1 of the 6th Directive. As does that see case of Van der Steen, it follows that treatment as a single taxable person precludes persons who are thus closely linked from continuing to submit VAT declarations separately and from continuing to be identified within and outside their group as individual taxable persons, since the single taxable person alone is authorised to submit such declarations. So in B.J. Rice, Mr. Rice was not required to be a taxable person at the time of the actual transaction. In our case, Silverfleet was not permitted to be a taxable person. As the court says, the closely linked person or persons within the meaning of that provision cannot be treated as a taxable person or persons within the meaning of Article 4 Sub 1. It's a general definition of what taxable person means. Now, the commissioners say that Silverfleet was required to be registered for VAT.
So can I just understand how that works? It probably isn't relevant, but so I can just get my head around it. Suppose a member of a group company supplies both intra-group services, which are covered by the group provision, but also supplies services to people outside the group. Does that mean that the invoices must be registered by the must be rendered by the taxable group?
It's so supplies by a VAT group member to non-group members are treated as supplied by the representative member. That's section
I see
4.
they're treated as,
Yes, for VAT purposes.
but in the real world, the actual invoice will continue to be by the subsidiary.
That would be a commercial decision, but it doesn't affect the VAT treatment,
Exactly.
which is to treat the
Okay.
representative member as the person making the supply.
Thank you. No, I'm sure it was a red herring, but
No, interested in this point as well. So, while it was a member of the Prudential VAT Group, if Silverfleet provided investment management services to a non-group client and rendered an invoice, VAT would have to be charged and accounted for by the representative member, which is the Prudential, but presumably it would still be Silverfleet that would send the invoice, the VAT invoice, because that's what the client's expecting to see, an invoice from Silverfleet. It would just that the VAT number on it would be the Prudential's VAT number. Is that right?
I would be speculating. Yes. So the legal entity that in fact makes the supply would be named on the invoice. The invoice would come from that entity. For VAT purposes, however, you treat the supply as having been made by the representative member, subject to joint and several liability by the group members.
But the whole point is you get a single VAT return from the representative member,
Yes.
which takes account of all the inputs and outputs of the group from outsiders, but ignores all transactions inside the group. That's what Section 43 requires.
Yes.
And so there's a single VAT number. They don't all have separate VAT numbers. And they may, and you would expect the representative member to be the accounting party and to be liable, but as you say, there may be provisions for joint and several liability for all the members of the group.
Well, there is such a joint and several liability provision in Section 43 itself.
Yes, I'm not surprised. Otherwise, you just load all the liability onto the representative member and you might not get the VAT paid. Yes, thank you very much.
The commissioners say that Silverfleet was required to be registered for VAT. That is, if I'm not misquoting it, it's paragraph 35 of the skeleton argument, which is the core bundle behind tab 4. On page 64. Starting under little 2 in the margin. The second point appears to be the basis for the first. It's misconceived. At the time when services were actually rendered, SCL, the Silverfleet, was required to be registered for VAT and was registered for VAT as an ordinary member of the VAT Group. But we know from CJEU judgment in Amplis Scientifica that Silverfleet, being a member of the VAT Group, cannot be treated as a taxable person within the meaning of Article 4 sub 1, the definitional meaning. So,
Are you saying that's an I'm being slow here. You're saying not a taxable person, but it was in fact registered for VAT.
I'm not quite sure what my learned friend means by the statement that when the services were actually rendered, Silverfleet was required to be registered for VAT.
Oh, I see. Sorry, I misheard.
I'm afraid I don't really know what that statement means. But what I am saying is that it cannot be true because we know from Amplis Scientifica that Silverfleet cannot be treated as a taxable person within the meaning of the general definition of what a taxable person is.
Can we just read on?
Yes.
It said, was registered for VAT as an ordinary member of the VAT group, of which Prudential was the representative member. Is that right?
Again, I am not sure what my learned friend means by was registered for VAT as an ordinary member of that group. What we do have is in the supplementary bundle a schedule setting out the members of the VAT group. It's tab 7 in the supplementary bundle. This was during the group period. And you can see it says, page 88, group registration, Prudential Assurance Company Ltd at the top. There's a registration number and highlighted 021 PPM Capital Ltd, which is the then name of Silverfleet. Changed its name. I don't know if that is what my learned friend is referring to, and I don't want to speculate on his behalf, but the point I'm making as part of my submissions is that none of this changes the fact that the European Court has said that when you are a member of that group, you cannot be treated as a taxable person.
And I follow that, and I know that's the point on which you rely. Just so I understand the context, there must be some statutory provision. I don't know whether at this time it was section 29 of the VAT Act 1983, which says that in some fashion you have to name the members of your group, I imagine.
There are provisions to apply for applying to the commissioners to be registered as a member, to become a member of a VAT group. Certainly the legislation that we have in the authorities bundle, I don't believe there is one that sets out a requirement for there to be a register of the members of a particular VAT group. But this is perhaps a point that I can come back to Chip on.
Yeah.
If you just give me a moment. We will look at that.
Section 43B, which we do have, deals with applications to the commissioners to be treated as members of the group, and gives powers to the commissioners to refuse the application on certain grounds. Otherwise says that it's taken to be granted.
As to whether there is a provision for whether there's a register of members of that group, that we will look into.
At any rate, it's not in dispute that you can be a member of a group, but on the other hand, you say that doesn't mean you're a taxable person.
Precisely. It's put a little more strongly than that by the European Court. It says you cannot be treated as a taxable person. It's not permitted. What the commissioners say, going back to paragraph 35 of their skeleton argument, on page 64, tab 4, about 2/3 of the way down that page, the ampli scientifica case, as I said, is of no assistance to PAC in the case. The CJEU concluded, given the single taxable person concept, that national legislation made pursuant to Article 11 could not permit individual companies affected to continue to have their own individual VAT identification numbers or to make their own VAT submissions. Neither the ruling nor the reasoning of the CJEU assists in the present case, but we say it's wrong to attempt to restrict the judgment in ampli scientifica in this way. As I've just read to you in paragraph 19 of the court's judgment, it's very clear. It says, thus, where that provision is implemented by member state, the closely linked person or persons within the meaning of that provision cannot be treated as taxable person or persons within the meaning of Article 4, sub 1 of the 6th Directive. Full stop. That's a general a statement of a general principle. And then the court continues, it follows that treatment as a single taxable person precludes persons who are thus closely related from continuing to submit VAT declarations, etc. And that is dealing with the very specific question in that case. It follows that, but that the first part of paragraph 19 is an announcement of a general principle. At this point, moving on, so each BJ Rise, having left BJ Rise, time of supply provisions cannot impose a VAT charge while one wouldn't exist at the time of supply. In BJ Rise, that was the case because Mr. Rise was not a taxable person. At the time of the actual supply, similarly here, at the time the investment management services were actually provided, Silverfleet could not be, cannot be a taxable person, was not a taxable person. Then I need to deal with a criticism that was levelled by Lord Hoffman in Thor Materials against the judgment in B.J. Rice that was picked up on by the Upper Tribunal, which is that B.J. Rice really, the decision of B.J. Rice really just depended on common sense. It says common sense and fairness. It is right.
Can we not see what, are you going to show us what Lord Hoffman said?
Of course, it's Thor Materials, which is tab 7 and page.
It must be 86 to 87, I think.
Yeah.
Yes, page 87, bottom of 86, top of 87. I explained earlier, the question of whether a supply is taxable often depends upon the time on which it is treated as having taken place. Thus, the question of taxability must be determined by applying the time of supply rule. The only alternative is to use some kind of meta rule derived from fairness, common sense, and other such concepts lodged in the judicial bosom. This seems to have been the technique used by a majority of the Court of Appeal in B.J. Rice. So that's what Lord Hoffman said.
But we ought to read to the end of the
Of course, my Lord.
paragraph. Time of supply rules are, in my view, the only criteria for deciding whether the transaction is to be treated as having occurred at a time when it was taxable.
In a dissenting judgment that...
Well, I dare say, but I mean, I think nevertheless, if you're going to comment on what Lord Hoffman said, we need to see all of what he said.
In that case, continues the
Well,
meta...
in that case, I don't know whether your lordships have started at page 86F, which is the passage sideline. I'd invite you to read down to the bottom of 87E. I apologise for interrupting my learned friend.
No, I'm grateful. So 86F down to 87E.
Yes, thank you. So you were going to say why what Lord Hoffman said was either wrong or distinguishable, apart from being dissenting, of course.
We say it's right that when construing any legislation, to have regard to the consequence and to adopt a construction that does accord with common sense and is fair and just. And to that extent, the criticism levelled at B.J. Rice is unwarranted. Those principles ought not to be controversial, but you can see them set out. If I could invite you to turn to tab 21 of the authorities bundle. These are extracts from venue, but they have been judicially approved. So, starting on page 356, if I could invite your lordships to read the sideline passages on page 356 and 357 and 359, the footnote 1 simply confirms that these passages have been judicially approved.
Yes, but well, this is all very familiar stuff. If you want to rub our noses, do. But that's not really what Lord Hoffman was saying. He was not saying, it'd be amazing if he was, that in deciding between rival constructions, you shouldn't look at what produces the more just or commonsensical result. He obviously wasn't saying that. He was simply saying in this particular case, you have a clear statutory rule, and he was criticising the Court of Appeal in B.J. Rice for substituting for the clear statutory rule some other rule based on its perception of what was fair. So I don't think you answer his point simply by saying we all know that you can look at the consequences of a construction in trying to decide whether it's right.
It's also the case, having taken your lordships through the judgments in BJ Rice and the careful reasoning that's set out there, that the decision in BJ Rice was not simply based on concepts of fairness or justice, but through a careful analysis by their
Well,
lordships.
that may be a better point, but all I'm saying is I think having a boxing match with Lord Hoffman on the basis that he misunderstood the rules of construction, I think is probably not your most the right battle to have.
Grateful, my lord. So the point I just made is also, having looked through the judgments in BJ Rice, they are very much based on a very careful analysis of the legislation by their lordships, and not merely on concepts of fairness or justice, although that does, of course, and should come into the analysis.
Just going back to the bottom of 86, Lord Hoffman says there is in the judgment of Lord Justice Beldam a suggestion that the time of supply rules presuppose that the supply is taxable, therefore cannot apply to a supply which must be disregarded. This, in my view, is logically impossible, and the commissioners did not support it. Is that different from what you're submitting?
Bottom of page 8, there is the judgment of Justice Beldam that the time of supply rules presuppose the supply is taxable and therefore cannot apply to a supply which must be disregarded. This, in my view, is logically impossible, and the commissioners did not support it. That is very much directly contradictory to the observation of Lord Nolan in the majority.
Well, I dare say, but my lord's point to you is the submission which Lord Hoffman was describing as logically impossible your submission? I think you're saying, yes, it is my submission, but it isn't logically impossible. Lord Nolan didn't think it was.
It is not logically impossible, no.
But it is the submission which he is criticising.
It is what I invite you to take from BJ Rice, and it is what has been criticised there by Lord Hoffman.
Yeah.
It's also the case that Regulation 90, being a deeming provision, shouldn't be taken, it's the same point, but shouldn't be taken so far that it produces effects clearly outside its purpose. And really it's the same point made in BJ Rice and in Lord Nolan's example, which is it's not the purpose of a time of supply provision, such as Regulation 90, to impose a tax liability where one wouldn't exist, did not exist at the time of the actual transaction. Because that would, in the context of VAT Group regime, we say give rise to an unjust or anomalous result. Because what it means is you don't treat what happened between members of the VAT Group as if it happened within a single entity.
Can I just think around that for a moment? Whatever the rights and wrongs of BJ Rice, one can see it has a common sense appeal. The majority decision has a common sense appeal. At the time the service was actually provided, neither the supplier nor the customer thought that there was going to be VAT. If it turns out later there's going to be VAT, either the customer is charged more than the customer expected to pay, or the supplier gets less out of the transaction than the supplier expected to receive. It doesn't feel quite the same with the Prudential's situation. Is it unjust for VAT to be payable in your circumstances?
It's unjust in the following way. What the VAT, as the European courts have said, and it's confirmed in Taylor Clark and Lloyd's Banking, one of the purposes of the VAT grouping regime is to give economic operators a choice as to whether they want to provide for supplies in-house or whether they want to acquire or render supplies to a fellow VAT group member. And to charge VAT in this case would be unjust because it essentially deprives economic operators of that choice. It's not a genuine choice. If they chose to provide the services in-house, there is no doubt that there would be no VAT consequence flowing from that. But if they choose to provide the same services between two VAT group members choosing to structure their business so that they create a VAT group rather than a single entity, there is, on the Commissioner's case, a very real VAT consequence. And so you're depriving economic operators of any real choice as to how to structure their business. And that's unjust. And is not in keeping with the purpose of the grouping regime.
Trouble is, to go back over old ground, it's difficult to see how you can quite map one onto the other. So suppose that some branch of Prudential wasn't a separate legal entity, had been supplying these management services to Prudential, and then suppose that that branch had been hived out into a separate legal entity which wasn't owned by Prudential. The new legal entity wouldn't, absent some new contractual arrangement, inherit any claim against Prudential at all. There could be no claim for a performance management fee or whatever it is, unless at the point of the hive out, there was a contractual arrangement entered into. There was no pre-existing contractual claim. It was just bookkeeping.
But that is the equivalence that is required if a member state chooses to enact that grouping regime. There's not an obligation on member states to implement a VAT grouping regime. But if a member state chooses to implement a VAT grouping regime, then the outcome it needs to provide for is that the VAT group is treated as a single taxable person. And as Advocate General Jaskinen said in Commission in Ireland, double check, that may mean that there are financial advantages to being in a VAT group, and that's an inevitable consequence of the operation of the regime. Check that point. It's yes, it's Commission in Ireland, tab 19, page 310, at paragraph 46.
Yeah, remember it.
So we say the Regulation 90 being a deeming provision should not be taken so far as to produce the result for which the Commission is concerned in this case. There is authority as to how far to take a deeming provision. I think Fowler and HMRC, just for your records, it's authorities tab 16, page 275. Perhaps we could just have a quick look at it. It's paragraph 27. But none of this should be controversial.
It's not controversial.
No.
What is controversial is how far you can take Regulation 90.
Yep.
And again, we've been through this point, so I won't labour it. Article 66 of the Principal VAT Directive, under which Regulation 90 was enacted, permits member states to derogate from the earlier articles only as regards when VAT becomes chargeable, given that there is a transaction. So very much not a provision that allows you to change the time of the transaction for the purpose of determining whether there is a charge to tax.
I go back to what Lord Hoffman said, because one of the things he said was directly contrary to that. That was in Thorn, which was tab 7, page 86. He said, as I explained earlier, this is H, the question of whether a supply is taxable often depends upon the time at which it's treated as having taken place. What does he mean when he said, as I explained earlier? What's he referring to?
Give me a moment.
This isn't right back at 82, is it? Where there's a paragraph, since the tax is levied upon specified transactions, it is in many contexts necessary to be able to say when the transactions took place.
Yes, or possibly even just earlier in the paragraph, respectively think, page 86, that this reasoning is fallacious. Paragraph A requires one to identify a supply which has occurred while the parties are members of the same group. And there's, in my view, no way in which one can identify such a supply except by application of time of supply rules.
I think it's implicit in your submissions that you're inviting us to say that's all wrong, and we don't have to follow it because it's a dissenting judgment, and actually Lord Hoffman was wrong in what he says there. Is that right?
It's not merely that. It's also that on the facts of Thor materials, there is no dispute that the real world transaction took place outside of that group, and one does apply one can apply the time of supply rules.
Yes, but Lord Hoffman, that's true, but Lord Hoffman is making a more general proposition than that. You may be saying, you say he's wrong, you may have a fallback position, he may be right, but he's only right in situations of the kind that were relevant in Thorn. But I just want to distinguish which you're saying. You're welcome to say both, but they're not the same thing.
Where there is a supply to which the timing rules, Regulation 90, can be applied, I don't want to pin my colours to mast. In this case, if Silverfleet had supplied services to Prudential when the two were not VAT grouped, and there were continuous supply of services, Regulation 90 would apply, and there would be a series of separate and successive supplies. But when the actual transactions take place inside a VAT group, and the VAT group needs to be treated as a single taxable person, you don't give effect to those transactions. You don't lift them out of the VAT group and apply time of supply rules to them to determine when they took place. You don't go into that deeming world because the transactions are to be disregarded for occurring inside a VAT group.
So I think what you're saying is Lord Hoffman may be right in some cases, that in order to determine the taxability of a transaction, you might need to apply the time of supply rules, but none of that applies in your case because all the services were supplied inside the group, and therefore you never get to the question of time of supply.
Indeed, my lord.
I
And,
think I think it's clear what you're saying. Thank you.
I mean, just following it up a moment longer. I mean, the bit on the next page, 87, where Lord Hoffman is talking specifically about BJ Rice, is flatly against you, isn't it? In that case, the meta rules led to the transaction being treated as having occurred at a time when it was not taxable. On the other hand, if the court had concluded that it happened at a time when it was taxable, they would presumably then have applied the time of supply rules, which may have treated it as having occurred at some other time. This cannot be right.
in my submission, it's not quite the right description of what BJ Rice decided. BJ Rice didn't decide that you couldn't apply the time of supply rules in that case. In fact, it was agreed that you do apply Regulation 23 in that case. And what BJ Rice decided was that, notwithstanding applying Regulation 23 in that case, you could not impose a VAT charge where or VAT liability where one didn't exist at the time of the actual transaction. So what Lord Hoffman says there is perhaps not quite the right description of what BJ Rice decided, which was not about whether or not you apply time of supply rules at all.
Do you, I mean, it looks as if Lord Hoffman thinks BJ Rice was wrong, but it wasn't, as you've said, it was a dissenting judgment. The majority didn't express any views on it.
The majority said nothing about BJ Rice.
Lord Clyde did have some remarks on page 89 about letter F. The provisions in sections 4 and 5 are of general application to establishing the time of the supply, whether or not there is a charge. The expression used for the purposes of a charge indicate that it's all for the purposes of a tax. Time provisions are for all the purposes of tax, but time provisions are to apply. That seems rather contrary to the reasoning, or some of the reasoning of BJ Rice, which relied on the words at the end of section 6.1, I think it is, saying for the purposes of the charge to tax. This seems to say, well, it's for all the purposes of the tax.
But then he moves on at page 90, where he talks specifically about VAT groups. And starting at the bottom of page 89, the scope of the section, section 29, which is now section 43.
Sorry,
So
where are you reading from?
Lord Clyde, it's the bottom of page 89.
Right.
The scope of the section, he's talking about what was then section 29, what is now section 43. So he's talking more specifically about VAT groups. Extends to the regulation of accounting for and payment of tax in the situation of a group. But in my view, it goes no further. It recognises supplies can be made between members and it regulates how the taxes be operated. One member stands in the place of each and all of them. For the purposes of the tax in such a group situation, supplies between members necessarily have to be ignored. But the actual existence of such supplies is recognised, even though those supplies may have no VAT consequence. Indeed, provisions may be made in accordance with section 29 sub 2 to cover such supplies by treating them as self-supplies. Where section 29 sub 1 sub A speaks of supplies between members being disregarded, that must, in my view, mean that they are to be disregarded for the purpose of that, while they're members of the group, and the single taxable person is the representative member. If the payment had been made in contemplation of and followed by a sale and delivery of goods to home, while both companies were still within the group, the supply could be treated as occurring at the date of the payment to the extent of the payment, although that would all be academic, because the supply would be disregarded for the purposes of that.
Okay.
And that part of Lord Clyde's judgment is much more directly on the issue in this case. And again, with regards to what I've just read out, therefore, what he said earlier in his judgment must be confined to the specific facts of Thor Materials, where the actual transaction, the passing of the ownership in the goods took place outside a group, and nobody was arguing that you don't apply the time of supply rules.
I mean, on the specific bit that Lord Justice Nugee was drawing your attention to, it begins, it was common ground. So that there was no issue on that particular point.
Indeed.
Thank you.
Great, my lord. So the next point, the next series of cases I need to deal with are the RSA, the Royal and Son Alliance cases. And that's because the commissioners say, and this is paragraph 32 of their skeleton argument, that the decision in B.J. Rice has been confined by what Lady Justice Arden said in the Court of Appeal in the RSA case, and what Lord Walker said in the House of Lords. We say, however, that neither what Lady Justice Arden said nor what Lord Walker said cast doubt on the reasoning or conclusion of the Court of Appeal in B.J. Rice for present purposes. If we could start in the House of Lords, tab 11 of the Authorities Bundle, page 147. If I could just invite you to read, this is the head note, just between C and D down to between E and F, just the facts there.
Yes.
So there was nothing about VAT groups in the RSA case. RSA happened to be the representative member of that group. Some members of which group were the lessees, but that wasn't critical to the reasoning at any level in that case. There was also no doubt in RSA that when the lease was granted by the landlord to the group members, it was a taxable supply made by a taxable person, and the cause or furtherance for business carried on by the landlord. So there was no argument in RSA against what we say is the ratio in B.J. Rice, which is that the existence of a chargeable transaction has to be determined at the time when the supply is actually made, and you can't impose a VAT charge at the time of supply rule. So with that distinction in mind, if I could invite you to go to the Chancery division in the decision in the Chancery division, which is tab 9. And then if we could turn to page 124, please. Starting just under little b in the margins, paragraph 50 of Mr. Justice Park's judgment in the High Court. He set out section 6 sub 1 and then subsection 14, which we went through earlier this morning. And then he continues at little e, so the section which created the power to make regulations 85 and 90, which were the timing regulations in that case, is only dealing with the time of the supply. It is not concerned with the nature of the supply. Other sections are, in particular section 5. For your record, section 5 is set out at page 114 of the bundle. And that distinguishes when a letting of a property is a supply of goods or services. The regulations should be construed so as to accord with and remain within the ambit of the power under which they are made. Authority in support of this, see B.J. Rice, close brackets. In my view, this confirms my conclusion that regulations 85 and 90 cannot be used by the Commissioners to convert the input to RSA into a series of successive inputs, each lasting for only 3 months, and each, if it arose in a vacant, unelected period, having expired before it could be used in making future supplies by way of taxable subletting. So, in a sense, Mr. Justice Park was taking the decision in BJ Rice further. There's no suggestion from the Court of Appeal in BJ Rice that had they been looking at a supply that was chargeable at the time it was made, then the timing rule, Regulation 90, could not have been applied to treat that continuous supply as a series of separate and successive supplies. But that's what Mr. Justice Park took from BJ Rice, and that reliance is what is criticised by Lady Justice Arden, then in the Court of Appeal. And the Court of Appeal judgment is behind tab 10. If I could please ask you to turn to page 141 and read paragraph 48, please.
So which page have we gone to?
Page 141 behind tab 10. And it's paragraph 48 from Lady Justice Arden's judgment.
Yes. Yes.
So what Lady Justice Lady Justice Arden was not saying, she's not suggesting that BJ Rice remains anything but good law for the principle she sets out there, that the time of supply rules could not result in the imposition of a liability to account for VAT on a person who was not a taxable person at the time he supplied and raised an invoice for the services in question. The reference to invoice, we say, is immaterial. It was relevant in BJ Rice only because it was not a VAT invoice. It wasn't a tax invoice, and therefore didn't create a time of supply at the time the invoice was rendered. That's why the invoice was important in BJ Rice. But it wasn't critical to the ratio in that case. What Lady Justice Arden is saying is that BJ Rice did not, as Mr. Justice Park had held, prevent the time of supply rules from applying to treat a single supply of lease, payable periodically, as a series of separate and successive supplies, each of which was then fully consumed at the end of the relevant period. And therefore you couldn't attribute it as an input to outputs in subsequent time periods. It was that reliance that Mr. Justice Park placed on BJ Rice that Lady Justice Arden is criticising. But she is not criticising what we rely on BJ Rice for. In fact, she's very clear at paragraph 48. She says BJ Rice, in that case, very different considerations arose because the issue was whether the time of supply rules could result in the imposition of a liability to account for VAT on a person who was not a taxable person at the time he supplied and raised an invoice for the services in question. And insofar as the case is sought to establish any wider restriction on the time of supply rules, see per Lord Hoffman dissenting. But we're not relying on BJ Rice for any wider principle than what she has set out there.
Except in your case, you say it's sufficient to say the time of supply rules could not result in the imposition of a liability to account for VAT on a person who was not a taxable person at the time he supplied the services in question. You say the raising of the invoices is a red herring.
The raising of the invoice was only a feature in BJ Rice because it wasn't a tax invoice. If it had been a tax invoice, a VAT invoice, it would have created a time of supply at the point it was rendered, which was when Mr. Rice was still not a taxable person.
Well, it couldn't have been a tax invoice if he wasn't a taxable person. But in our case, the services were all supplied intra-group. But the invoice was only raised after Silverfleet had left the group, because it was only then that the payment was due. But you say that makes no difference to the ratio, the principle of BJ Rice.
Indeed. And then finally, there is what Lord Hoffman says in.
You mean Lord Hoffman or Lord Walker?
Lord Walker. Apologies, what Lord Walker says in RSA in the House of Lords, and that's behind tab 11. Page 168. Paragraph 83, it says, in my opinion, Lady Justice Arden was correct in her analysis and conclusion as to the scope of section 6.14 regulation 85. And this does not necessarily involve saying that BJ Rice was wrongly decided, as it was concerned with a different factual situation, an invoice sent to a client before the consultant was registered for that. On this point, I cannot usefully add more to the observation of my noble learned friend Lord Hoffman, whose opinion I have had the advantage of reading in draft. And again, same point about the invoice. Something's been lost in translation there, my submission, because the invoice was not a critical part of the reasoning in BJ Rice.
Well, it was part of the reason, certainly of Lord Justice Ward, who said that at the time that the contract was entered into, you wouldn't expect, neither side would expect VAT to be payable, which is reflected in the invoice that was sent. It was only for £150, not £150 plus VAT. And that imposing VAT later meant that one or other of them would lose out. Can I go back? You may have answered this already, but what happens if at the time the services are supplied, the supplier is not taxable, but at the time the invoice is rendered and the payment is contractually due, his turnover is increased so that he is now a taxable person? What is the position then?
BJ Rice tells you that there is no.
Please speak up a little.
Sorry, my lord. BJ Rice tells you in that situation that there is no tax liability, because the rendering of a VAT invoice, same as the payment, creates a time of supply under Regulation 90, but nevertheless, that doesn't impose a VAT liability where one didn't exist at the time of supply. If you look at Regulation 90, which is behind tab 3, no, apologies, behind tab 2 in the authorities bundle, on page 24, where services are supplied for a period for consideration, the whole or part of which is determined or payable periodically or from time to time, they should be treated as separately and successively supplied at the early of the following times, each time the payment in respect of the supplier is received by the supplier, or each time the supplier issues a VAT invoice relating to the supply. So the issuing of a VAT invoice would have the same effect as the making of the payment in BJ Rice. It is treated as a separate and successive supply, but nevertheless, applying the reasoning and the conclusion in BJ Rice, it wouldn't create a tax liability if one didn't exist at the time of the actual transaction.
But of course, if you did issue a VAT invoice and it were paid, you would have to account for the VAT. My recollection is if you issue something purporting to be a VAT invoice and you get the money, you have to hand it over whether or not it was actually...
Schedule 5 in paragraph 11. So there's nothing in what Lady Justice Arden said in the Court of Appeal in RSA that suggests BJ Rice is wrong in establishing the principle on which we rely. What she is saying is that Mr. Justice Park took it too far in saying that BJ Rice established the principle that you couldn't apply the time of supply rules to treat the real world supply as a series of successive and separate supplies of VAT purposes. And we don't rely on BJ Rice for that principle. We were in the judgment of Lord Walker in RSA, and he says, on this point, I cannot usefully add more to the observation of my noble and learned friend, Lord Hoffman. And Lord Hoffman, all that Lord Hoffman says on this point is at paragraph 36, which is on page 156. Perhaps I could invite your lordships to read the sideline passage.
Just 36, yes.
So all that what Lord Hoffman is criticising is this: I find the notion of the same goods or services being supplied over and over again being too hard to grasp. In my opinion, the plain effect of the regulation is to treat each successive supply as different from the one before. On this point, I agree with the Tribunal and Lady Justice Arden. That is not what we are arguing here. I've made my point, we're saying that Regulation 90 can't impose a tax liability where one didn't exist at the time of supply. And it's a simply completely different point. And RSA post-dated Thor materials, but Lord Hoffman says nothing in his judgment about BJ Rice specifically.
One sees, just looking at the next paragraph, that Mr. Gammy,
Yes.
subsequently at the First Tier Tribunal, has referred to Thorn, but I think on a different point.
He refers to Thorn for the what is said in there about he was making the point that the time of supply rule in Thorn was different because it treats the same supply as supplied to a certain extent at the time of each payment or rendering of invoice. And what Lord Hoffman then goes on to say is that he rejects that argument because they are different time of supply rules. Regulation 90 is not worded so as to treat a single supply as supplied to varying extents at different times, but rather to treat the supply as separately and successively supplied at various times. So therefore, he says at the top of page 157, I reject the analogy. So it's a short point, but BJ Rice has been before higher courts on a number of occasions, and it hasn't been disapproved on the principle on which we rely on it for. So we say it remains good law, establishing the principle that timing rules can't be used to impose a VAT liability, where when the transaction constituting supply actually takes place, there is no VAT consequence. And it's not, I believe, controversial that if the time of supply in this case, if one had looked at payment of the performance fees when the services were in fact rendered, when Silverfleet and Prudential were members of the same group, there would be no VAT liability. So that moves me, that was a very long ground one, but it is the longest. Ground 3 will be extremely short. But ground 2, which is ground 2 because it's in a separate category, because this was the basis on which the First Tier Tribunal found for Prudential, but rejected by the Upper Tribunal. And that starts again from the assumption that it is right to apply Regulation 90. And we say it can't generate a VAT liability of Silverfleet, nevertheless, because Regulation 90 cannot change the fact that the supply was made in the course or furtherance of a business carried on by Prudential as the representative member and not by Silverfleet. And that's the assumption in the first part of Section 43, which we've seen, that treats the businesses of group members as carried on by the representative member. And that's confirmed in Taylor Clark, in Lloyd's Banking. I can just give you the references without going through them. Taylor Clark is Authorities tab 13 on page 196. And Lloyd's Banking is in tab 15, page 264. Lady Justice Rose, there's there, paragraph 175, little 1. The wording of Article 11 of the jurisprudence of CJU precludes the model of VAT grouping adopted by the UK, where the VAT group appoints a member of the group to be the representative member and attributes the businesses of the other members to the group, to that representative member, who then accounts to HMRC for VAT arising in transactions in that business. So even if it were right not to disregard Silverfleet's provision of services to Prudential during the group period, those provisions were made in the course or furtherance of a business carried on by Prudential, and it cannot create a VAT liability of Silverfleet.
Can we just clear up something which I put to you earlier, but I just want to make sure I'm right about it, what the relationship is between the introductory words of section 43.1 and the A, B and C, but for our purposes A and B. What I put to you was that A and B was doing no more than spelling out the consequences of what the First Tier Tribunal called the assumption made in the opening words. And I've noted down that you agreed. And we were discussing, one of my lords believed, and indeed it rang a bell with me too, that one of the authorities actually says no, that they are rejected the argument that, which I put to you, that you could read the word and at the end of the first part of 1 as if it was and therefore. I'm not sure this is relevant to the point you're making, but I think it might be, and even if it's not, I want to clear it up. Can you, do either you or Mr. Mantle remember an authority that
It's
says
Lord
something?
Hoffman in Thorn, my lord.
That's very helpful. Can we just look at that? I'm sorry if this is taking you off your course, but we'll have to do it at some point. Which particular?
So it'll take me a second if you forgive me. I think it's on page 84, beginning, I beg beg your
No,
pardon.
it's 85. That's
It is 85, beginning, I think, just below D is the relevant passage.
that's the last sentence of the last two sentences of that paragraph.
At F, for the purpose of the assumption.
Yes, well, that's certainly the passage which whichever of us it was had in mind. Thank you. Let me just see how he's using it. Well, thank you. I don't think I want to ask any questions about that at the moment. It's probably not relevant to the point you were just making, or is it?
It may well be relevant,
Ah.
might be relevant, which is that assumption 1 treat all the businesses of the VAT Group members as being carried on by the representative member. Assumption 2, or deeming 2, disregard supplies, we say transactions, that must include real world transactions between group members. And deeming 3, deem any supply to or from a third party outside the group made to or by the representative member. And those are slightly different points. And my apologies for going against what I've said earlier, but those are slightly different points from the assumption in the first part of section 43, which is that you treat the businesses of all group members as carried on by the representative member. And it's a simple point. There is no authority for what the commissioners are necessarily having to argue, which is that Regulation 90 can be applied to create a supply that, notwithstanding when it was actually made, was made in the course or furtherance of a business carried on by Prudential, into one that was made in the course or furtherance of a business carried on by Silverfleet, so as to impose a VAT charge on Silverfleet. When the transactions in fact took place, which was inside the VAT Group, Prudential is treated as carrying on all the group members' businesses. But when it comes to charging VAT on Silverfleet, which is what the commissioners are saying should be done in this case, it has to be Silverfleet that is carrying on the business in the course or furtherance of which the supply is made. That is section 4 of the VAT Act, which is Authorities tab 1, page 4. VAT shall be charged on any supply of goods or services made in the United Kingdom where it is a taxable supply made by a taxable person in the course or furtherance of business carried on by him. And Regulation 90 can't change the identity of the person carrying on the business. Otherwise, what happens when Regulation 90 is applied to a supply, where the invoice or payment, and therefore the time of supply, occurs at a time when the supplier is no longer carrying on a business? Does that then become a non-taxable supply? Supplier supplies continuing services, or services on a continuing basis, in the course or furtherance of a business that is then carrying on. At a later point, when the supplier has ceased carrying on that business, it renders a VAT invoice, or it is paid for the supply. If Regulation 90 has the effect of saying that is a supply made in the course or furtherance of a business carried on by the supplier at the time of the deemed supply, the supplier isn't carrying on a business. Does that then render that supply non-taxable? It would be astonishing if it did, and frankly, it would be open to abuse if it did.
What is the position? If you're carrying on a business, I suppose you're a barrister. and your turnover is such that you're vatable and then you retire, you receive fees after you retire, do you pay VAT on them? I think you probably do, but I don't know why, I don't know how.
We say you do because all that Regulation 90 does, it doesn't change. What it does not change is it doesn't change the identity of the supplier. It doesn't change the identity of the recipient. It doesn't change the business in the course or furtherance of which the supply is made or who is carrying on that business. What it does change is the time of supply for the purpose of the charge to tax, the legislative wording. And so in the case of a barrister who then retires, if the supply, assuming it's a continuing supply of services, is made at a time when it is carrying, in the course or furtherance of a business, but paid for or invoiced later, Regulation 90 doesn't have the effect of saying, now we look at what business the supplier is carrying on at this point of invoice or payment. Because that would generate a result, in the case of a retiring barrister, of saying, well, the taxable person is not carrying on a business at all, so it can't be charged a tax on this amount of consideration. And that would be wrong.
I mean, I see all this. Is it realistic? I don't think this defeats your point, but is it realistic to suppose that Regulation 90 would apply to the barrister?
Continuing the supply of services it would be for
Would you not, as a barrister, supply a series of one-off services rather than supply services in the sense with which Regulation 90 is concerned?
it would be difficult to think of a situation where Regulation 90 would be engaged.
So outside Regulation 90, in the case of the retiring barrister, the time of the charge would fall to be determined separately.
But it's a short point. Regulation 90, and indeed as the FTT correctly found, Regulation 90 cannot have the effect of changing the identity of the person who's carrying on the business in the course or furtherance of which the supply is made. And if Silverfleet, even if it's right to apply Regulation 90 to generate a series of separate and successive supplies made each time a VAT invoice is rendered or payment is made, if they were not supplies made in the course or furtherance of a business carried on by Silverfleet. And so it cannot create a tax liability of Silverfleet.
And that is so, whether Silverfleet carried on managing investments as a business for other people, which it presumably did, or not, because your point is all that they are getting money for is providing services which therefore they would deem not to be carrying on a business.
If Silverfleet were providing investment management services for non-group members, third parties, whilst a member of the VAT Group, those would be treated as supplied by Prudential as a representative member. That's section 43 sub 1 sub B. Silverfleet's business is also treated as carried on by Prudential. That's the first part of section 43. So the tax liability falls on Prudential as the representative member. And that's how it would operate in that scenario.
Yes, that wasn't quite my question was, once it's left the group, Silverfleet is presumably carrying on the same actual business as it was doing before. It's now treated as carrying it on its own account, not as being carried on by the Prudential. But that doesn't affect your argument, which is the time of supply rules can't treat the services that were in fact intra-group as if they were supplied by Silverfleet in the course of its own business.
That is right. And so if there is a rendering of invoice or a payment after Silverfleet has left the VAT Group, but referable to services in fact supplied whilst it was a member of the group, the liability remains on the representative member. It doesn't then move to Silverfleet simply because Silverfleet has left the VAT group in the meantime.
Thank you.
Now, as you pointed out, this point loomed very large in the FTT decision. The FTT, as you say, focused on this point and linked it with BJ Rice, whereas you've dealt with BJ Rice in the context of your first ground. Do you say, well, if BJ Rice helps me, it's going to win me on the first ground and forget about it on the second ground, or how do they relate to each other?
So BJ Rice, in a sense, I've inadvertently confined BJ Rice to the Silverfleet is not a taxable person point, because that is how the commissioners have tried to confine BJ Rice, which is they say the decision in that case is confined to a situation where the supplier is not a taxable person. But we say the ratio in BJ Rice goes wider than that. And indeed, BJ Rice is also relevant here because one of the 4 criteria for imposing VAT is that the supply is made in the course or furtherance of a business carried on by the person on whom VAT is sought to be imposed. And if that criterion is not met at the time of supply, BJ Rice says you can't use a time of supply rule to then impose a VAT charge at a later time. So whether you take the ratio in BJ Rice more widely and say any of the 4 criteria, one or more of the 4 criteria for imposing a tax liability is not met at the time of the actual supply, there is no VAT charge and it can't be imposed by time of supply rule, in which case BJ Rice applies, is relevant both because Silverfleet is not a taxable person at the time of the actual supply and because it wasn't carrying on a business. Or if you take the commissioner's submission that BJ Rice is narrow and is restricted to saying when the supplier is not a taxable person, then that applies only to one half, as it were, of my submissions rather than the other half. And really that then moves on to ground 3, which is very short and it crosses over with much of what I've said already. It's this part of the Upper Tribunal's judgment where it says that the case doesn't concern that the consequence of that grouping. The Upper Tribunal's judgment is in the core bundle behind tab 6. It's paragraph 1, sorry, page 98. Page 98, paragraph 108. We see nothing, the Tribunal says, in these objectives, so talk about the objectives of Article 11 set out in Commission Ireland. We see nothing in these objectives which supports the position of either party in relation to the issue in this appeal. Insofar as Ms Young referred to EU authorities regarding the effect of Article 11, as we have said above, the issue in this appeal is not the consequence of Section 43 sub 1 where it applies, but whether Section 43 sub 1 applies to the supply of services in the first place. Article 11 is permissive in nature and creates no directly enforceable rights in the United Kingdom. Reference to the Rentier case, it is for member states to specify their domestic legislation, in their domestic legislation, precisely what close links are necessary between two persons in order for them to be treated as a single taxable person. In our opinion, Article 11 sheds no particular light on the issue in this appeal. It's a little confused, but insofar as that paragraph says that this appeal is not about the consequence of applying Section 43, it is wrong, because no one is disputing, as a matter of fact, that Silverfleet and Prudential were members of the same VAT group at the time that the investment management services were actually provided. And so certainly during that period, one does apply Section 43, and one is looking at the consequence of applying Section 43 during that period. And you've had my submissions on what those consequences ought to be, based on the objective that you treat members of a VAT group as a single taxable person. Or in the words of the Commission in its communications, you treat the VAT situation of the group as fully comparable to that of a taxable person with different branches. So the Upper Tribunal and the Commissioners really start, we say, from the wrong point, which is they lift the transactions that in fact took place between two members of the same VAT group out and allow it to have VAT consequence and apply Regulation 90 to those transactions. And that approach has not been endorsed in any authority, and we say it is wrong. And that just leaves me to respond very briefly to some of the points that the Commissioners have made in their skeleton argument, but that was a short ground three.
Just before you leave ground three, you said more than once that we have to construe Section 43 of the VAT Act in conformity with Article 11 of the CJEU jurisprudence. What are the words in Section 43 that you invite us to construe, and how do you invite us to construe them? What is the point of construction?
I invite you to construe in Section 43 sub 1 sub A, where it says any supply of goods or services by a member of the group to another member of the group shall be disregarded. For supply, refer back to Section 5 of the VAT Act, which defines what supply is. Section 5, subsection 2, little a and little b, as something that is done. So anything that is done, so going back to Section 43, little 1, little a, anything that is done for consideration by a member of the group to another member of the group shall be disregarded. But of course we know from authorities such as Thorne and Svenska that you do also disregard deemed supplies. So that includes when you have a actual transaction that occurs outside a VAT group but is deemed to occur inside a VAT group by timing rules, you also disregard those, and that's Thorne Materials and Svenska. But for our purposes, where it says a supply of goods or services, you disregard anything that is done, actually done, for consideration between group members.
Thank you.
Or transaction, indeed, in the language of the Principal VAT Directive. So just a few short points to respond to arising from the Commission's skeleton argument. They say at paragraph 11, for your reference, core bundle tab 4, page 56, that it has been decided that the UK model of VAT group will comply with Article 11. We don't dispute that. We say Section 43 sub 1 sub A is compatible with the objective of Article 11 when properly construed in the manner that we invite you to construe it. But if it is construed in the way for which the Commissioners argue and the way in which the Upper Tribunal decided it ought to be construed, then it's not compatible with that objective. Because it fails to treat Silverfleet and Prudential as a single taxable person during the time they were VAT grouped. But properly construed, we don't say that it's incompatible. Then at paragraph 27 of the skeleton argument, my learned friend's skeleton argument, there's a point made that the approach to the application of the time of supply rules should be consistent between sections 43 sub 1 sub A and sub B. We say there's no inconsistency in the following sense. The reference to supply in both subsections would include transactions or occurrences that actually take place during the group period. That's my Lord Nugee's point that I just made submissions on. Where it is a event, an occurrence, in PVD language, an occurrence taking place between members of the same group is disregarded, has no VAT consequence. That's subsection A. Whereas an occurrence taking place between a group member and a third party is treated as taking place between the representative member and the third party. That's subsection B. And any VAT liability in that case attaches to the representative member and remains there, even if the real world supplier then leaves the group. Then there is paragraph 47 of Commissioner Skeleton argument, full bundle tab 4, page 70. That derives from paragraph 4 of the respondent's notice, which is, for your records, core bundle tab 2, page 27. It says on page 70. PAC has never contended that it did not carry on business at the time of supply of services, if Regulation 90 does apply to them. What is more, in the real world, the business carried on by PAC at that time was not distinct from the business which the appellant had carried on when the relevant services were actually rendered. I think that must be a typo, because Prudential PAC was the recipient of the real world supplies, and we have never argued, and we are not arguing, that Prudential did not carry on the business at the time of the actual transaction. And as the recipient of the services, whether or not it was carrying on a business has no impact on the VAT liability of Silverfleet, which is what we're talking about. Even if the Commission is meant to refer to Silverfleet, where they refer to the appellant and PAC, the fact remains, I've said it, that when it was grouped with Prudential, Silverfleet's business was treated as carried on by Prudential. And that's the business in the course of furtherance of which the investment management services were supplied. There are, next point, there are arguments that are said by the Upper Tribunal in their decision.
Is this still a point on the skeleton?
No, this is no longer removed on my separate point. A point is made by the Upper Tribunal in their judgment granting permission to appeal to your lordships that there are arguments said not to form a material part of the arguments below. The commissioners don't object to the arguments being advanced. That's paragraph 5 of their respondent's notice, which is core bundle tab 2, page 27. So you have my submissions at footnote 1 of my skeleton argument.
When I saw all that, speaking for myself, I thought as the point to be conceded, we didn't need to grapple with it.
I won't trouble your lordship with it.
I think I speak for my lords, they're not kicking me under the table. Yeah.
So the final point is this: stepping back from what may appear to be a tangle of legislation, one is faced with a choice of two different constructions. On the one hand, there is our construction, which we say gives effect to the purpose of Section 43, construed as to be compatible with Article 11, giving economic operators a genuine choice as to how to structure their businesses, such that provisions made in-house and provisions made between members of the same VAT group are treated equivalently, because the VAT group is treated as a single taxable person, and the transactions between members are disregarded, are a nullity for VAT purposes. On the other hand, the outcome for which the commissioners argue and the Upper Tribunal decided, which is not a genuine choice because it means that providing these services within a VAT group does generate a VAT liability, whereas making the same provisions in-house in a single legal entity does not. And we say it would be wrong to adopt the construction for which the commissioners contend, because it would be contrary to the purpose of the VAT grouping regime. If you could just give me a moment, my lords. Unless I can assist you further, those are my submissions.
Okay, thank you very much, Ms. Young. That's been extremely helpful.
My lord, thank you. Can I just start with something His Lordship, Lord Justice Nugee, mentioned at the beginning. In our submission, it's not helpful to get tangled up, as First Tier Tribunal did, in anxieties between mixing the real world and the VAT world. But it is important to note, we would say, that before you get to the question of whether Section 43 applies, Section 43(1), and what its effects are, so momentarily put that to one side, it's clear that in the real world there was a supply for consideration made from Silverfleet to the appellant, who I'm going to call PAC. And all conditions for chargeability of VAT that are real world conditions were met at that time. Of course, one requirement for the chargeability of VAT is that the supplier be a taxable person. That's in, as you've been taken to Section 3 of the Value Added Tax Act, somebody who is registered for VAT or required to be registered for VAT. And there's a point of contention on that, and I think it's fairly obviously not going to be able to complete today, so I'm going to be coming back tomorrow, and I'll try and deal with the point your lordships raised about obligation to enter names of members of a VAT group which are not the representative member on some sort of list or register. But it's clear that, if nothing else is clear, that Silverfleet was not outside the scope of the VAT system in terms of having no connection with VAT registration at all. It was VAT registered in the sense that it was an ordinary member, that's any member apart from the representative member, of a VAT group of which PAC was the representative member. So that's something I will need to come back and deal with. but it just sets up this point. In order to succeed in this appeal, PAC has to rely on the assumption or disregard the totality of section. Forgive me for a moment. 43. I'm tempted to say 42 for some reason. Section 43 of the Value Added Tax Act. So, in our submission, that is good justification for the start that the Upper Tribunal made in approaching the exercise of statutory interpretation, which is before you. The right approach is to start with section 43(1) and interpret it. Now, what the appellant is seeking in this case is to have a supply of services disregarded. And that means that the most obviously relevant provision of section 43(1) is paragraph A, which we've been referring to as the disregard. And that's where my learned friend starts in her submissions, and it's where the Upper Tribunal started in its reasoning. And just for a moment, my learned friend, I don't think has attacked the Upper Tribunal for its approach. It might not be an entirely typical one, but it's not an unusual one in our submission of having decided that there was no authority which bound it in deciding the issues in this case, that it should look first at the legislation and interpret it, and then go to the cases that have been cited to it and see whether the conclusion it had reached on a preliminary basis, just by looking at the legislation, applied.
Speaking for myself, not only is it not an unusual approach, I thought it's, unless there is very clear authority, it's a better approach. See what you think it means, and then see whether the authorities lead you to a different conclusion, willingly or unwillingly.
I can see that that's recommendable. And although at earlier stages in the litigation, the commissioners had suggested that some of the House of Lords cases were binding, and my learned friend had suggested on behalf of the appellant that B.J. Rice was binding in the First Tier Tribunal and also bound the Upper Tribunal. We did modify our position before the Upper Tribunal, and we accept that nothing binds you on this point. There's no scenario considered by the House of Lords which is absolutely indistinguishable from this one. Nevertheless, perhaps this is the moment to say that we also contend that you're going to find, or have already found, some very strongly persuasive reasoning in judgments in the House of Lords, which is important, if not fundamental, to the conclusions that were reached, or steps to the conclusions which were reached, that by and large they are extremely supportive of the approach that the Upper Tribunal took, and by and large they are really inconsistent with the approach that my learned friend urges upon you.
Let's get down to brass tacks. Sorry, I'm sorry, I've just got your point, but
I think your lordship would like me to go to the most important passages in the authorities.
No, I meant the opposite. I mean, let's look at what your submissions are and what the section 43(1)A means.
Well,
sorry, I really didn't mean to interrupt. You were on the point of saying let's start with section 43(1)A, and then we got diverted into how the authorities help. let's look at 43.1a.
Yes,
That's what you were
but-
going to do.
It was probably obvious I didn't need to make that point, but that's what I wanted to do, was
Yep.
go to section 43.1a. That's in tab 1 at page 10. Could I just invite you to read again 43.1a and b?
Yep.
And just a note, because it was referred to earlier by His Lordship Lord Nugee, the very last sentence at the end of one, all members.
Both very keen on elevating both my lords, Lord Justice Nugee and Lord Justice Newey. You may only be ahead of the day at the time, but
maybe late in the day. Could I also, just before we look at the opening words and A, the disregard, which are the most important, could we just look at C as well, very briefly? And you'll see that here there are references to acquisition of goods from another member state, so intra-community acquisitions and importation.
Yes.
So, to make this point, my only friend seems to think that somehow reference to a supply isn't very illuminating and one should use the word transactions. That was argued in front of the Upper Tribunal. In our submission, that doesn't really assist her at all. What you have here is a reference to a number of transactions for VAT purposes: supplies, intra-community acquisitions, and imports. And they all have, within the VAT system, the PVD and VATA rules which deal with the time at which they occur. And just to remind you what a transaction is for VAT purposes, if you'd be so kind, back to page 20, or sorry, forward to page 29 in the bundle at 4. You see Article 2, the following transactions shall be subject to VAT, and then there's a list of certain types of transactions, including inter-community acquisitions and importations, and of course supplies. So it's entirely appropriate for the UK legislation, section 43.1, to deal with particular types of transactions as it does, and it's no worse for referring to supplies rather than transactions. It's more particular in doing so in our submission, trying to conceptualise something as a transaction rather than supplies of no assistance at all in interpreting this provision. Could we go back, because we might as well have it out, to section 43 itself, which is on page 10.
yes.
And the tribunal in our submission inevitably and correctly recognised that there was a temporal requirement in relation to section 43.1a. It's necessary to establish whether the supply of goods or services was made by one member of the group to another member of the group, and therefore one has got to ascertain whether the supply was made when both supplier and recipient of supply were in the same VAT group. So you're required by 1A to decide when the supply took place. There are only two alternatives in our submission. One is to apply the time of supply rules in VATA. Those time of supply rules are either mandated or permitted to member states by the Principal VAT Directive, PVD. And there's no complaint made by PAC that they're inconsistent with the directive. They obviously make points about how if they are applied in certain ways, that may be contrary to EU law. In our submission, as the Tribunal importantly recognised, there can be no doubt that the concept of supply in section 43(1)(a) and the concept of supply in regulation 90, which is we agree if a time of supply rules applies at all, it's the time of supply rule that applies in this scenario. They have the same concept of supply.
Can I just check? You said there were two possibilities. Are we still on the first possibility, or has the second possibility got lost by the wayside?
We have ended happily the first possibility. So it's applying the time of supply rules here, regulation 90. The second possibility is what Lord Hoffman describes as a meta rule.
Yeah.
You have to make up your own rule, to put it shortly.
Well, it's not the rule suggested by Zhang is not a meta rule of the kind referred to by Lord Hoffman in Thorne, which are all to do with fairness and justice and soft concepts of the kind he clearly didn't like. She says that the rule is equally hard-edged to the time of supply rules. It is the time of actual supply of the services. Isn't that the alternative we've got to deal with? Or am I missing something?
Well, with respect, my lord, I don't think if you're missing anything, you're missing very much. But that would be to, in a scenario such as this, it's an invitation to dispense with the time of supply rule, which is detailed and clear in its effect. It's actually an invitation to read something into the time of supply rule that has the effect of the time of supply rule not applying at all. It says, don't look at the time of supply rule, just look at when the services were actually rendered. I don't think what she suggested to you leaves any alternative, with one right, and I'll come back to applying first, ascertaining first the date when the services were actually rendered. And she says if the services were actually rendered when the two companies were in the same VAT group, then the disregard applies. I think she says it's not as simple as that, though. So I think she says if you apply the actual services rendered test, and that shows you that the services were actually rendered at some point of time outside when both were members of the VAT group, and this is certainly the argument below, and I've heard at least traces of it here, and I think it's a skeleton argument, that you then apply regulation 90, and if regulation 90 were then applying the time of supply rule to put the supply that was actually made, let's say after one member had left the VAT group, back in the time when they were both in the VAT group, again, the disregard would apply. I'm sure she will tell me if she'll tell us.
I didn't hear her say that. Well, yeah, unless I missed it.
I think it clearly flows from what she said to you.
Well, that was sort of an invitation, Ms. Yang. Without making a speech, do you recognise the submission that's attributed to you?
If what my learned friend means is the following: actual supply takes place outside a VAT group. Application of time of supply rules means you have deemed supplies happening inside a VAT group. And Thor Material and Svenska tell you that if there are disregards to be applied, there are disregards to be applied. I don't know if that is what my learned friend is.
Well, let's not get into a debate. Thank you. I heard what you said.
I think that was what I summarised.
Okay, well, I may have misunderstood.
And we would say what you're really being invited by us to do, and what the Upper Tribunal said it was proper to do, is to apply the time of supply rules from the PVD and VATA to establish whether a transaction, sorry, I shouldn't say transaction, whether a supply is made at a point in time where there are two members of the VAT group. So is it an internal transaction of the VAT group at all? So in establishing whether it's an internal transaction of a VAT group, one should apply the VAT time of supply rules. That's normal, it's uncomplicated, it gives legal certainty, and in that sense, it's certainly not unfair. And it's also applying time of supply rules, if we leave BJ Rice aside momentarily, which apply throughout the VAT system in order to address various provisions in it and their application, which is a point I think Lord Hoffman makes eloquently in his judgment in the Thor Materials case. On the other hand, in our submission, and this doesn't necessarily mean it's wrong, but it makes it less attractive. One has a complex position. The complexity, if PAC's line is adopted, the complexity is in looking at time of supply potentially twice, sometimes once, only looking at when services are actually rendered, sometimes looking also at the time of supply rules. That doesn't begin to deal with the complexity of it, though, because here I'm very happy to accept that we are dealing with a type of supply where we can say with certainty that the services actually rendered by Silverfleet to PAC began after they were both members of the VAT group and ceased before Silverfleet left the VAT group. But there will be other situations. For example, there will be situations where you clearly have some sort of straddle, some continuous supply of services that begins when both are in the same VAT group, but only ends after one has left, or both have left. And your lordships went through some examples of difficulties. VAT is either famous or notorious because of the number of different varieties of businesses and supplies, including supplies of services, but perhaps particularly supplies of services that can be made. It may be that somebody's on call to make services throughout a period, only called on to do so after a date when one member's left a VAT group. There may be all sorts of complicated contractual terms about consideration in that and other circumstances. So that's the straddling case. And my learned friend is quite right. There's a standard provision in VAT, section 19.4, which we'll get for you tomorrow, which deals with where consideration has been paid for something that is a supply and consideration has been paid for something that isn't a supply. So a good example of that is where you play for a game of bingo. Part of what you pay will be a stake, which goes towards prizes, and the rest of it will be consideration for the provision of the bingo game. So that's the type of situation it normally applies in. I can see here the possibility of it applying if you disregarded the time of supply rules and you say that, well, we've got a continuous supply that straddles that group and not. We're just going to say, well, that actually occurred, or we measure it in some way before and after, and then we apply the general provision. But there's nothing specific dealing with it. And that would also mean, I think inevitably, that not only would you be not applying the time of supply rules to establish whether or not a supply was made when the two members were in a VAT group, it would also mean that even after the one member had left the VAT group, if there was a continuous supply, you wouldn't be applying the time of supply rules in the usual way, because it wouldn't be creating successive supplies of services, different services in the way, and you'd somehow have to be dealing with apportionment and consideration in a way that wasn't founded on the rules for time of supply. I think, can I just take you back to the Thorn case?
Yes,
Or-
I'm just looking at the time.
Well, maybe it would be better for me to do that in the.
How are you doing? It's generally the person who goes second I expect to be shorter because we covered most of the ground. Have you any predictions?
I haven't had the chance to speak to my clients, of course, since lunchtime. I would hope that I would be finished by lunchtime. I'm not sure at the moment that I could do justice with it.
Yeah, very well. No, I was just wondering whether I'm trying to finish now rather than start on Thorn. Yeah. I think we'll finish now and start again at 10:30 by the clock, which is now right. Whether it will be tomorrow morning is another matter.
Thank you, my lord.
What about the